Welcome to Constellations, the podcast from Kratos, where industry leaders share their thoughts and experience on the future of space business, policy, and opportunity. If you like Constellations, please support us by giving a rating and review on iTunes. And don't forget to share this podcast online to help our community grow.
Welcome to Constellations, the podcast from Kratos. My name is John Gilroy, and I'll be your moderator. Today, we welcome Kevin Myhre, patent attorney. The concept of intellectual property, or IP, is complex but critical to foster innovation in all industries. But how does it work in space? In such a booming industry, how is this new technology protected? While the number of countries and commercial players involved keeps increasing, it is important to understand how innovation is regulated and, most importantly, protected. In this case, we do not only cross borders, we go into space. Is a patent granted in the United States still valid in outer space? That's what we hope to find out today with our guest, Kevin Myhre, patent attorney with a background in aerospace engineering who has worked on numerous patent applications for space-related innovations, both for the government and commercial sides. Kevin, can you walk us through the history of intellectual property in the space industry?
Yes, absolutely. Yeah. Thank you for having me on the podcast today, John. I'm happy to participate and lend some insight on IP protection. So first, I think if we're going to talk about IP and its intersection with space or space law, I think it makes the most sense to just sort of take a step back and I think say, well, how does intellectual property protection apply generally, right? And so I think that leaves the framework for then how we can sort of discuss its intersections later on. So we're used to very territorial rights in intellectual property. So maybe we can use patents as an example. So patents, as you may know, are granted in a particular jurisdiction, like the U.S., for example, and the holder of the patent can prevent others from making, using, or selling whatever invention is claimed in that patent in the jurisdiction. So, for example, if a competitor is making an infringing product in some other state in the U.S., we could potentially stop them from making, using, or selling it according to the claims of our patent. But if we only have that U.S. patent and someone is making that product in France, for example, and only using it and selling it in Europe, our U.S. patent is going to let us stop them. And trademarks and copyrights are somewhat similar in that they're both registrable with the government and are similarly territorial. Importantly, and this is sort of a side point, but you can file related patent applications on your invention or trademark applications in other jurisdictions to sort of extend that protection, obtaining very similar, even potentially the same protection in these other areas and other territorial jurisdictions. But the real point is that you'd have to apply to each individually, right? They're separate forms of protection. We obtain them separately and they're tied geographically. So I think this is an important groundwork for how space-related inventions can be protected and enforced. As you might be able to see, right, this system of territory-based rights works well for innovators or holders who are based in single countries. It can work well for multinational corporations that have large organizational infrastructure and can coordinate protection across these different jurisdictions. But it does tend to get a little uncertain once we start to move off the ground, which is what I'd like to discuss next.
Yeah, so that leads to the question here. So how does intellectual property law, IP law, intersect with space law?
Right. Yeah. So with the background of the territorial protection, there has been some discussion and some interesting intersection with IP, and the question's been around for quite a while. But the intersection of IP with space law has been mostly tangential. So if we look back, and I know nothing says riveting like an old treaty, but the Outer Space Treaty of 1967 is probably the first thing to at least sort of address how we might apply IP rights in space. So in that one, it outlined that outer space itself is not appropriated by any particular country, but that objects launched into space are different. So a country of registration retains a jurisdiction and control over the space object while it's launched into outer space, and registration is the country that launches it or procures launching or from whose territory it's launched. So there's a focus here in this outer space treaty on the entities that are entering space as governmental entities. I think is kind of an interesting aside here is that at that time, everything was very, very governmental. So there wasn't much contemplation about commercial actors entering this space in the future. So everything was very much based on, right, what country was it launched from? What country owns this vessel or object that's in space? And so from that treaty, we can kind of say that for our IP purposes, we can say that this IP protection applies on that vehicle launch from that country of registration. So if we have, for example, a space shuttle launched from the U.S., in theory, we could extend these provisions of the Outer Space Treaty to say that our IP protection would then also apply on this U.S. space vehicle because it is under the jurisdiction of the U.S. Right. So that was sort of the background or sort of initial intersection with intellectual property. More on point, the U.S. has the U.S. Patents and Space Act, which is literally entitled Inventions in Outer Space. I won't bore you with the actual opaque legal language here, but it does say, similarly to what we were gathering from the Outer Space Treaty, that inventions made, used, or sold on a space object under U.S. control or jurisdiction are considered made, used, or sold within the U.S., right? So we're extending that jurisdiction, even if it's in space, as long as that object is registered to the U.S., then that counts as United States jurisdiction. There are some exceptions there in that law. So it doesn't apply to an object specifically identified by international agreement to which the U.S. is a party, right? So if there's an object in space like the International Space Station, if that's subject to some sort of international agreement, then this does not fall under this U.S. Space Act, the Patents and Space Act. And it does not apply if it's registered in a foreign country, even if it's under U.S. control. So if a vehicle launched from another country, despite being under U.S. control, it's not considered U.S. jurisdiction, at least for patent purposes. The Act does get into what happens if an invention is made in space. So this says that as long as it's on a U.S.-controlled space object, it's also deemed created in the U.S., similarly to how it would be if that invention were created territorially on the ground. And the International Space Station, there's an agreement covering that separately. It also covers it similarly, where it says that if there are multiple objects or connected with each other that are separately under registrations of various countries, then those separate elements are each the jurisdiction of that individual country that has that component, right? So, and I think this is probably the most fascinating part of the intersection of IP with space is that's kind of about it in terms of actual attempts to outline enforcement of IP in space. Trademark does not have anything similar and requires jurisdictional registration like a patent. Trade secret is not registered, right? It's something that you protect by yourself. And there's protection by international agreement in many countries, but nothing about the applicability in space. So it's very much a developing area of law. How does IP apply, especially once these objects reach space? But I do think that it still is very applicable to a lot of space-related businesses. And so I think the question is, with this background and with these developments in space law, sort of where does it leave us if we're a space-related entity that's looking to innovate and looking to protect our innovation? Well, we have this very well-established territorial framework for protection, and we have somewhat fuzzy implementation in space. But as I think we'll get into here in a few minutes, that's not quite as big of an issue as it seems, at least for right now. But I think we will discuss some on sort of where that might head in the future and how that could be fixed as we spend more time in space.
Well, Kevin, you seem to know a lot about law, and I know a lot about human beings. And I'll tell you one thing, where there are humans, there will be disputes. It's going to happen.
Yes,
it's part of being human. I don't know why. It's just the way humans are. And so Let's put this in perspective. So why is intellectual property increasingly important for space-related businesses? Is these pesky humans getting involved here, or what's going on?
To some extent, yeah. I think that's the answer, yeah. So as we've discussed some already, much of the industry has long been government driven. Like as we saw with the Outer Space Treaty, the focus was really on these national entities creating these spacefaring objects and launching them into space. And there wasn't much of a focus on, well, maybe some commercial businesses could enter into this area. But I think as a lot of people who listen to this podcast have probably noticed, and as you've discussed with some other guests, R&D in space and even larger scale innovations are increasingly trending away from the state-owned large governmental organizations to private commercial organizations. So one aspect I think that drives the importance of IP is just kind of the increase in the number of entities in this area that could be working on similar projects, right? So we're moving from, you might say, fewer, very large governmental entities who weren't really facing competition from others within their jurisdiction. So sort of tracing back to our initial conversation on territory, right? If we think about NASA creating rockets and launching them, right? They're not facing, or at least they weren't in the past. There weren't many other entities that were building rockets and launching them within the U.S. So if at that point NASA had pursued a number of patents, and they had to some extent, but not in the sense that they were looking to cover every particular aspect of their innovation. And they didn't, because there just wasn't the same level of competition that there was, or that there might be once a lot of these commercial actors move in. So we're moving from these fewer entities to more numerous private entities that sort of are crowded within the same territorial area. And private businesses, sort of as you suggested, John, also tend to be somewhat more conscious of competition, and they're more proactive in having control over their own developments, and usually in chasing the profits for their corporation, are more willing to both protect their own innovations and use that to improve their competitive position in the market, especially when they've had significant investments in a lot of these R&D projects. But I think it's also important to note too that it's not just, an intellectual property in general is not just about excluding everyone else. So it's not as if a lot of these companies are coming in and just saying to one another, well, I'm just going to grab up these intellectual property rights and try to push other people out of these segments of the market. They're often also used, and we think in a lot of cases often better used, through various types of agreements. So as we've seen some of too, we might have governmental entities working with commercial entities, and if they're both bringing their own innovations to the table, maybe working together to produce something else that might in itself be innovative. Usually that's best controlled through various types of agreements, and both of these entities are in a much stronger position if they have that IP protection to bring to the table, right? So it's kind of a combination of increased action in the area, and then also using that IP protection to be able to get you not just keep other people out, but be able to allow you to maybe forge some of these collaborations or agreements with other businesses that could really propel everybody forward.
Kevin, thousands of people from all over the world have listened to this podcast. Go to Google and type in Constellations Podcast to get to our show notes page here. You can get transcripts for all 100 plus interviews. Also, you can sign up for free email notifications for future episodes. Kevin, I know you're in the Philadelphia area. If you were in downtown Philadelphia, you might hear an argument that would start with something like, okay, give me an example. And so
sure.
I don't want to talk like I'm on a bus in Philly or something, but give me an example. Can you briefly describe how the forms of IP could be used to protect these different aspects of space-related businesses?
Sure. Yeah, of course. Yeah. So I think our conversation so far is a little abstract. But if we can focus on some examples, I think that helps ground what we're talking about. So as many are probably aware, there are really four main types of IP. So we have patents, trade secrets, trademarks, and copyrights. So in the space context, really each of these can apply. So patents are most likely a tangible device, but could also be a process or software. One example we might use would be a propulsion system. Maybe we can use that here to sort of flesh out what a patent can get you in this area. So what's particularly interesting about the patent side is that the scope of the protection can vary significantly, and it depends on how the application is drafted and what claims are allowed. So if we invent a propulsion system, we could try to cover just one small innovative portion of it. And if that patent is drafted correctly, it could cover other uses of that particular innovative element in other propulsion systems, or it might cover uses of that element in other applications. Or we could try to cover that propulsion system as a whole and leave out some of the other details that are more based on existing technology, right? So we're potentially catching some infringers who would make that propulsion system, but maybe change around some of the existing things. Ultimate lesson there being that on the patent side, it's not just the protection on the exact device that you've created, but it can extend beyond that. And it also doesn't even really need to be a device. It could be a different process that results in maybe the product at the end of the process is the same. Maybe it could be a metal with some particular coating that helps it last better in a space environment. But maybe we have a process that applies that coating in a different manner that makes it adhere better, or something like that, right? So the end device is the same, but the process is an improvement on existing technology. So that's something that could also be the subject of a patent.
I'm just thinking about the bus in Philly, and someone says, give me an example. Well, I don't say give me an example. What I say is, in order to be terrific, you got to be specific. So I'm going to give you a real specific question here, and you can bounce around with it if you want. So let's say my daughter owns a company, and she acquires intellectual property, IP, for a certain technology. And so where is it enforceable? Does it change between the ground and then a certain level it's air, a certain level it's space? Or so how does this all alter?
Yeah, so I think and I think it's most useful to start with that patent example, because it might be the clearest here. But if we have that propulsion system, right, suppose going back to the first part of our discussion, if we have a U.S. patent on the propulsion system, it would extend to anywhere in the U.S. So we could prevent others from making, using, or selling that propulsion system in the U.S. So if someone builds that system in the U.S., they could potentially be infringing it. Even if someone builds it elsewhere, moves it to the U.S., puts it together, and then uses it in a way that reads on the claims of our patent, they could be infringing there too. So that's the ground perspective. Air is usually pretty similar, right? The jurisdiction of the territory extends some distance above the ground before you get too far into too far above the ground when you start to approach space. And then space, we sort of address some with the Space Protection Act we were talking about earlier, where as long as that object was registered in the U.S., if it is in space, then it is still could potentially be infringing the U.S. patent, because it is a U.S. registered object that is using the technology we have covered by the patent. Some of the other forms of IP too could potentially be interesting to talk about here. So you could use like a trade secret maybe as an alternative to a patent to protect various types of IP of space-related industries. So a trade secret could be used to protect any kind of information that has value by not being generally known and is held and protected as secret by the owner, right? So we don't have to file for anything here. This is more about a company using various obstacles and confidentiality agreements to make sure that some sort of their secret sauce, like you could think about maybe the Coca-Cola formula, is protected and is not just sort of generally out there. The major benefit of trade secret is that it can potentially last forever as long as you keep it secret, but it only protects from outright stealing. If someone else independently discovers it or would happen to reverse engineer that trade secret, then they're free to use it, right? Whereas with a patent, we sort of talked about that broader level of protection where even if someone starts to use it independently, it didn't really intend to copy your invention, they could still fall within the claims of your patent. And trademarks also could potentially apply to some of these space-related businesses. You could think about, for trademarks, you think about branding, so identification of a source of goods or services. This could be maybe a name, a logo. We could think about some particular examples like Blue Origin or SpaceX, and these are restricted to the types of goods and services that they're used for. So Blue Origin, for example, is then registered under a number of different things we might expect, like travel services and launching commercial payloads. But they might also register under like toys or publications, so that other uses of that mark too are protected. And those trade secret and trademarks similarly apply, right, as we discussed, between that sort of territorial type of protection. And then space is a lot less certain than the patent side, where we discussed that there's that Patent Act that extends to U.S. registered space objects. But I think really the key, and going back to talking about sort of that difference between protection in ground, air, and space, I think the key thing is that the lack of concrete IP development is maybe not as restrictive as it seems, because like in our propulsion system example, right, the key, at least right now, is that the vast majority of things are not being practiced or created solely in space, right? So any potentially infringing action is probably going to happen somewhere terrestrially before it can reach space. Like, we need to build that propulsion system, or we need to launch it from somewhere which would likely be using that invention, right? So because we are reaching space frequently, but not spending a lot of, at least in person, not spending significant time there yet, don't have settlements or that sort of thing, our terrestrial system actually sort of works for right now. I guess you might think of an example where it might not work. Might be, for example, like a satellite, communication satellite. Maybe it has some sort of function that is only used once it reaches space. And in that case, I think we're back to the Space Act extension of patent protection to U.S. launch vehicles type of situation. But yeah, I think for the most part, it's right. Space protection is open-ended, but I think that sort of territorial protection still works in the vast majority of cases, for right now at least.
In my previous question, I carefully used the word enforceable. But I think if we went to Google and typed in job description patent attorney, it might say, well, geez, patent attorneys maybe counsel companies as far as what they can do. They maybe apply for patents and trademarks, because that can be a complex process. And then the other part is the enforcement. So there's a whole lot to this whole area of patents and patent attorney, isn't it?
Sure. Yeah. So we do really that whole range of services, ranging from actually filing for the protection, including consulting on what can be protected, how we can protect it, that sort of thing. And then enforcing it down the line too, if it does come to that.
You know, Kevin, we've been doing this podcast for 4 years. We used to have Made in Space on the air, and I never dawned on me during that interview to ask them about trademarks and patents. I mean, it's the last thing I thought about. I was just dazzled that they could print stuff out in space, you know? It just shows you how fast this industry is changing. So how do you keep up? How does IP law even keep up?
Yeah, and I think that's the interesting question too, right? As we've discussed, it's really territorial. And for now, it's working because most things need to happen here somewhere on Earth before they're launched and reach space. But I think really anybody can see that, right, coming up at some point when there's more of a presence in space and things are being developed there, or maybe even invented on these space on vessels in space, right? Then the question becomes much more complicated, and because we're no longer just being able to tie something back to an Earth jurisdiction and say, okay, well, these frameworks that we have now work, right? The further we get away from Earth, and the less we're sort of intersecting with some particular area of Earth, the current system starts to lose its effectiveness, which I could certainly see happening over the next 10 plus years or so. There have been some pretty interesting proposals for how we might deal with this going forward. There's a World Intellectual Property Organization that has, in very very early stages, not in any sort of, hasn't made much progress. Sort of like a thought leadership kind of article that they put out, but they proposed for a unified patent law and jurisdiction space. So essentially saying that, okay, we can have our terrestrial protection, but as far as things apply to space, we might have a single patent application that is universally enforceable throughout space. So space itself would be kind of a single territory that all these international, all these bodies would agree to as something that's kind of separate from our territorial protection there. And there is some precedent. They have set up a patent application system that centralizes some filing elements across the world. Europe has gone from multiple member states, right? So like France or Germany or England, where you can file individually, and you can still do that. But now Europe also has an alternative single patent process where you can obtain one that covers multiple jurisdictions, right? So that could potentially be an analogy here for how we might approach this problem in space.
Kevin, space law has been around for a while. I think 1967, you mentioned that earlier, but never has it had much interest until the last few years. I'd like to thank you for giving our listeners an introduction to some legal concepts involving intellectual property in space. I'd like to thank our guest, Kevin Myhre, patent attorney.
Thanks, John. Yeah, happy to participate.
Thanks for listening to Constellations, the podcast from Kratos. If you like this interview, please subscribe, tell a friend, and give us a review.